parties in this case are a number of class action plaintiffs who owned Xbox 360s and allege that they didn't work the way they were supposed to, they scratched CDs, and that they're entitled to relief. The question here is whether plaintiffs can get two bites at the apple in reviewing class certification. Microsoft v. Baker is the next step in a litigation dispute that has occupied the courts for decades. Many courts used to have something called the death knell doctrine that permitted an interlocutory appeal even though there wasn't a final decision, because of the idea that if individual plaintiffs could not receive class certification, they wouldn't bring their action. In Coopers and Lybrand versus Lynsey, the Supreme Court unanimously rejected that position. The issue in Microsoft v. Baker is whether a class action plaintiff can create final jurisdiction over the interlocutory issue of denial of class certification by agreeing to dismiss his claims with prejudice. So the district court in Microsoft v. Baker denied class certification on a variety of grounds. There is a rule, Federal Rule of Civil Procedure 23F, that permits an interlocutory appeal on a denial of class certification, but it's discretionary by the appellate court, and the Ninth Circuit here denied review. So Baker filed papers that asserted he was dismissing his claims with prejudice. A dismissal with prejudice binds you in future cases. You can't raise your claims again. Baker also asserted that he reserved the right to continue to bring his claims should, on appeal, the Ninth Circuit rule in his favor on the class certification decision. The Ninth Circuit let the plaintiffs proceed with the appeal on the grounds that they had an interest in seeking class certification, and went ahead and reversed, holding that class certification might have been appropriate in this case, and that the district court applied the wrong standards. This differs from what every other appellate court to resolve the issue has held, and Microsoft took this case to the Supreme Court. Microsoft's main argument is that the plaintiffs are trying to have it both ways. That they've dismissed the case, but that they've said we get to take back our dismissal if something we like happens in the appellate court. These plaintiffs have no standing to raise any claims because they've waived their underlying causes of action by agreeing to a voluntary dismissal with prejudice. Baker's saying that we asked the district court to dismiss our case. We reserved our rights to bring it back up if we won on the class certification issue. And there's no difference between the two. So if Baker does win, it permits plaintiffs to have a strategic advantage when bringing class actions. It gives them two bites at the apple in seeking class certification when defendants have to win every time they're faced with it, or else they're placed under tremendous settlement pressure and the plaintiff's lawyers can extract money from the defendant regardless of how meritorious their case is. But if Microsoft prevails, then we have uniformity of the circuits, and there is still no death knell doctrine, and then the only recourse for appellate review of a class certification decision is the discretionary review under 23F, and plaintiffs and defendants will be on an even footing there.